Hello.
Yeah, hello. Yeah, good morning, Your Honor.
I just was in the courtroom and I was told to go to
Okay, we are on the record to the people of the state of Michigan versus Desmond Charles Howard Henley, 2355581. Mr. Henley is charged with one count of police officer assaulting, resisting, and/or obstructing. Today's the day set for a probable cause conference. Appearances.
Good morning, Your Honor. Eric Decker, P85931 with the people.
Good morning, Your Honor. Mark Hyder, P35143, on behalf of Justin Henley.
Can you repeat one more time our audio with the volume?
I'm sorry, Your Honor. Mark Hyder, Haidar, P35143.
Thank you. Is Mr. Henley present?
Yes.
Mr. Henley, can you state your full name?
Justin Henley.
Thank you. Any discovery issues?
Your Honor, I would ask that he just send it to my email, and I will put that in the chat. And
Does that mean there are discovery issues?
I'm sorry?
Attorney Haydar, you haven't received discovery yet, correct?
That's correct, Your Honor.
Okay. Mr. Decker,
That will be on that tomorrow as part of that, Your Honor.
Attorney Haydar, send the email address to me since the prosecutors, they're not on Zoom right now. Send your email address to my chat.
All right. And then, Your Honor, we just requested an exam date.
Okay, so I have March 1st, March 2nd, March 6th, and March 7th as the earliest dates.
All right.
March 1st is not good.
March, yeah,
Which day did you say that?
March 1st is good, Judge.
I think Mr. Henley said that was a bad date.
Oh, that's a bad date? Okay.
Well, somebody said it. I'm not sure who the woman is.
Did you say you had March 7th?
Yes, March 7th is open. I have 9:30 or 10 o'clock.
9:30.
Wonderful. Okay. Mr. Henley, so that means your exam is set for March 7th in person at 36th District Court at 9:30 a.m. Okay?
Yes, thank you.
What courtroom? Is that 438?
You have to announce who you are. We're on the record. So if you're not a party to this case, then and he doesn't need help speaking, then I need him to speak for himself.
Wanda Henley, his mother.
Okay, Mr. Henley, back to the device and ask those questions. This is his case, I believe.
Yes.
Okay, Mr. Henley needs to come back and ask those questions.
Your Honor, we got the date. We'll and I put the email in the chat. Thank you very much.
All right, I have it.
I will call Mr. Henley and his mother.
Okay, it's courtroom 438.
Yes, thank you, Your Honor.
Welcome. Okay, are you ready for the email address?
Yes.
Mark Haydar, MarkHaidar.
Hot man. What's next, AOL?
Right.
Oh, the joke's on a Thursday morning.
Wait 7 days. Tether, bed, for treatment would not be available. That's why. No, I would like to tether for that treatment.
Okay.
Thank you. Ready on easily?
How you doing?
Hi, is the attorney person on easy or is
They may have.
Yep. Yeah, he on here.
Yeah, good morning.
okay. Case number 2355163, the people of the state of Michigan versus Lasana Easley. Mr. Easley is charged with one count of weapons carrying concealed. Today set for a probable cause. Mr. Harrison.
Morning, Your Honor. Eric Decker, P8593, the people.
And good morning, Your Honor. Neighborhood Defender Service by way of Emily New, P85234 on behalf of Lasana Easley.
Mr. Easley, can you state your full name for the record, please?
Lasana Easy.
Thank you. Any discovery issues from you?
No, I do believe I have everything. We just need an exam date.
Okay. So we have March 1st, 2nd, 6th, and 7th, we have open for just one time at 9 o'clock. And after that, after the 7th, we have everything open. For the rest of the attorneys too, if you're listening, you want to check.
You said the 7th was open?
Only at 9 o'clock, but after the 7th, we have a wide open calendar.
Oh, wide open after. Could we do the 10th at any time that day?
Okay, let's. Can you do 9 o'clock?
I can.
Okay. All right, Mr. Easley, your preliminary examination has been set for March 10th at 9 o'clock in person at 36th District Court, okay?
Okay.
All right, anything else?
No, thank you,
No.
Your Honor.
Thank you.
You want?
Your Honor, before you start, my name is Giovanna Jordan. I've been bounced from courtroom to courtroom. I have a paperwork indicating that I should be in your courtroom, Miss Sabree, Judge Sabree. I just was sent to another courtroom in which they told me that was landlord tenant. But I have the ticket number. If you can tell me that I am in the right courtroom, it comes up as my sister name, Bianca, because this is her laptop. But my name is Giovanna Jordan.
Ms. Morris, it's very rude of you. We're in the middle of handling some cases before our 9 o'clock case will start. You just give me a moment, I can get you to the right courtroom. But just give me a second, okay?
Okay, because
I think what the best thing to do, you can call the clerk and she can look up in the system what's going on. But just give me a moment, just trying to check in attorneys because we have a large docket today. And I know you're not on our docket, so we're gonna get you to the right courtroom.
okay.
You gave it phone number? Okay, so Ms. Morris, the clerk is chatting with you. You know I use the chat function?
My name is not Miss Morris. My name is Giovanna Jordan.
Okay, but do you know how to use the chat function?
No, ma'am, I don't.
Okay, we'll call this phone number 965-2406.
Okay, thank you.
Ready on Terry Williams?
Yes, Your Honor.
Okay. This is case number 2355520, the people of the state of Michigan versus Terry Williams Jr. Mr. Williams Jr. is charged with count 1, criminal enterprises, conducting criminal enterprises. Count 2, stolen property, receiving and concealing a motor vehicle. Count 3, attempted larceny from a motor vehicle. Count 4, stolen property, receiving and concealing a motor vehicle. Count 5, stolen property, receiving and concealing a motor vehicle. Count 6, stolen property, receiving and concealing a motor vehicle. Count 7, 8, and 9, stolen property, receiving and concealing a motor vehicle. Count 10, weapons, firearms, possession by a felon. Count 11, weapons, felon, firearm. This is a habitual offender for defense notice. And Mr. Williams is defendant number 1 on this case. except for a probable cause conference appearances.
Your Honor, I apologize. We're looking to see if this is, another APAs because it sounds like a tattoo case. We're just gonna, we're checking on that right now to see if there's a different APA that's on this.
Okay. And defense counsel, can you put your appearance on in the meantime?
Yes, good morning, Your Honor. May it please the court, Joseph Arnone, P68572, on behalf of Mr. Terry Williams, who is present and seated next to me in my vehicle because the power's out in my office. So I apologize, Judge.
Oh, no, that's fine. Mr. Williams, please state your full name for the record.
Terry Williams, Jr.
Okay, and have you received discovery yet, or?
I have received discovery, Your Honor. I believe it's complete, but it is voluminous.
Okay.
Your Honor, it's Dennis Doherty's on that. We're sending him an email right
Okay. You have me safe, send your family?
Yes, Your Honor. We would be asking the court to set an in-person exam date. I spoke with the attorney for the co-defendant, Mr. Welch, yesterday. I believe he has discovery as well, and he's scheduled for a probable cause conference before this court on this upcoming Monday morning. He and I both have scheduling conflicts until sometime in the second week of March.
Okay, thank you for letting me know that. So I'm gonna set a date, and then if the APA assigned to this case has, I'll have them email you all to get another date. But I want to get it on the calendar now.
Thank you, Your Honor.
Thank you.
So second week of March, let's see, we can do March 10th. That's a Friday.
What time, Your Honor?
Let's see, we have 9:30, 10:30, 11 o'clock.
Let's try 10:30 on March 10th, Judge. Only because I that's usually when everything is clear for myself and defense counsel. If there's any problems, the attorney for the people can contact me.
Okay, wonderful. Anything else?
Nothing for the defense, Your Honor.
Okay. All right, you have a good day.
Thank you. You and your staff as well.
Thank you.
What was that date again, Your Honor?
March 10th at 10:30. Parties ready on April Johnson?
Ready.
This is the people of the state of Michigan versus April Johnson, case 2355029. Ms. Johnson is charged with 1 count of police officer assaulting, resisting, and obstructing. They set for a probable cause conference appearances.
Good morning, Your Honor. Eric Decker, P85931 for the people.
Good morning, Your Honor. Matthew Forrest, P73168, appearing on behalf of April Johnson, who's present via Zoom.
Ms. Johnson, can you state your full name for the record, please?
April Johnson.
Good morning.
Good morning.
Okay, any discovery issues?
No, Judge, I believe I have received all discovery. I'd ask the court to set the exam for March 6th if available.
Okay, I have 9 o'clock and 9:30.
9:30 is good.
Okay. All right, so Ms. Johnson, your preliminary examination will be March 6th in person at 36th District Court at 9:30, okay?
Yes, Your Honor.
All right, anything else?
No, Your Honor, thank you.
All right, you all have a good day.
You too.
Thank you.
Yeah. Oh, okay. The lawyer ain't got here yet. Yeah, she's coming. Oh, gotcha. I'm bringing her back up. Yeah, he is here.
Okay, each other parties ready?
We're ready on Harmony Sneed.
Okay.
Yeah. Bring them down. These are the officers. It's like it's 9 o'clock.
Okay, we're on the record. This is the state of Michigan versus Harmony Ayana Sneed, 2355378. Ms. Sneed is charged with 1 count of uttering and publishing. Today's day set for a probable cause conference appearance.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Good morning, Your Honor. Attorney Kevin Basant, P71061, on behalf of Ms. Harmony Sneed, who's also present by Zoom video, Your Honor.
Ms. Sneed, can you state your full name for the record, please?
Yes, Harmony Ayana Sneed.
Okay, good morning.
Good
Discovery issues, Attorney Scott?
No discovery issues, Judge. I do have discovery, and I was hoping if we can set this for a preliminary exam on your March 1st date, Your Honor, if that's still open.
It is still open, yes. So I have 9 o'clock, I have 8:30, 9 o'clock, and 11.
Let me just ask my client, Ms. Sneed, does that work for you at 9 o'clock on March 1st?
Yes, that's fine.
Then that's good for me, Judge. I appreciate it.
Thank you. Okay, so Ms. Sneed will be in person at 36th District Court, March 1st at 9 o'clock, okay?
All right, thank you, Judge.
You're welcome. Y'all have a good day.
You too.
Thank you. Ready? Take the call.
I'm very sorry, Your Honor. I was talking, this is, what was the Sneed date?
March 1st at 9 o'clock.
Thank you.
Mr. Travis Jones. You have to unmute your device, Mr. Jones. Attorney McRipley, are you ready on your client's case? I like it right there. That way I can get it. Okay. Attorney McCoy, good morning.
Good morning. I'm appointed on Terry Williams, but I saw that Joseph Anon had appeared. So is he, I'm assuming he's retained?
Let me see the file. Terry. Is that for 2 days?
Well, I wish I'd have shit about this.
Mr. Jones, we can hear you, so stop. The language, we'd appreciate it. Thank you.
Good morning. What you need help with?
I'm looking at the register of actions. It has you as the attorney. I don't know what, I didn't know that.
All right. Yes, sir.
Yes.
Okay.
Yeah, I have discovery. I haven't had a chance to talk to the client, but I did just see that Mr. Anon was appearing. So I don't know if he's retained, but if Mr. Williams is here, I would like to talk to him in a breakout room.
No, we already called the case. He was here and left because we set an exam date.
Then that would have been because it would have been with Attorney Anon then?
Attorney Anon has Ms. Heath logged in for Mr. Williams.
Yeah, that's the case that I was appointed on. So he must have been retained then. So, okay.
That's who is on, well, actually, yeah, he's on the register of actions on the docket for our known as his attorney. Do you want to speak to Mr. Williams for some clarification?
I don't have a number for him. Is he in the court or did you have I tried to call a number for him and it didn't work.
Okay, well then we wouldn't have anything different. I don't have a different number.
Okay, I'll just check with this attorney unknown. So, okay, thank you.
Attorney McRipley, good morning.
Good morning, Judge. I am here on Alexander White, and he is on the screen.
Okay. Calling case 2355205, the people of the state of Michigan versus Alexander Xavier White. Mr. White is charged with count 1, weapons, firearms, receiving and concealing, count 2, weapons carrying concealed, count 3, weapons, felony firearm. Today's the day set for a probable cause conference. Appearances.
Good morning, Your Honor. Eric Dackerty, 5931 for the people.
And good morning, Your Honor. Rachel McRipley appeared on behalf of Alexander White. My P number is 76222, and Mr. White is present. Can you please state your name, Mr. White?
Alexander White.
Good morning. Any discovery issues?
No, I just recently received a discovery. I would ask that this matter be set for a preliminary exam.
Okay, I have for March 1st, I have 8:30 and 11 o'clock.
March what?
March 1st.
Is it possible, I know that the beginning weeks of March are booked for me. Is it possible to get the 13th or the 17th?
That's fine, as long as you're okay with that date, being that far out. What day did you say?
Either the 13th or the 17th.
Let's do the 13th. We can do it 10 o'clock.
That's fine.
Okay. So March 13th at 10 o'clock.
Yes.
Okay, Mr. White, that'll be an in-person exam, okay? You understand that?
Yes, ma'am.
Okay, so March 13th, 10 a.m., 36th District Court, okay?
Yes, ma'am.
All right, anything else?
Nothing further, Your Honor. Thank you.
All right, you all have a good day.
All right.
Attorney Anderson, good morning.
Good morning, Judge.
How are you?
I'm fine, thanks. I have Alverno Bigham, who apparently should have 2 cases before you.
I see, yes.
And
Okay. It's 9:01, give him a little time.
He's
If you
here.
want him read- Oh, he's here in person. He's in person, Attorney Anderson.
he is.
Yeah.
Well, I needed the opportunity to talk with him. Let's see. Maybe we could just, if I could get a good phone number for him, I'd like to set both of these matters for a preliminary examination. Either that or, well, to move the cases forward, I'd probably like to set them both for preliminary examination. Give me an opportunity to talk with him.
Okay. He doesn't have a cell phone, but I'm seeing if we can have him call. You do have a cell phone?
Yeah, but it's not mine. I'm using somebody else.
Okay, well,
But I didn't know that. I didn't, normally they give you a number.
that's fine. Okay, so he has a phone. He can call you in the hallway. You all can talk and then we can go back on the record.
Oh, that would be great. My cell is area code 313-719-1402.
Okay, so we'll have him call you out in the hallway and then when he comes in, I'll call the case.
Thank you. Thank
You're
you.
welcome. Attorney Jefferson, good morning.
Good morning. I'm here for, I'm standing in for Attorney Thomasine Jefferson, and it's for Nataya Gibson.
I don't see Ms. Gibson on the docket today. How you spell Nataya? We're looking it up.
Well, the last name is G-I-P like Paul, S-O-N.
Okay. And how do you spell the first name?
It's like N, one second. It's N-A-T-A-E-Y-A-H.
Okay, give us one moment.
Okay.
Hi, okay, you should be in Judge Giles' courtroom.
All right, thank you.
You're welcome, have a good day. Attorney Waldhorn,
Good morning.
good morning, how are you?
Oh, so far so good.
Good to hear. You have, let's see, Mr. JaVale Hicks, is that correct?
Yes, Your Honor.
Okay, he is not present. Are you looking to waive his presence today, or do you want to wait for him?
I'd be happy to waive his presence. I did talk to him yesterday.
Okay.
I've submitted a request for discovery, but I've yet to receive it. So we would like to adjourn the PCC if we can do that.
Your Honor, are
We
we
need to on the record.
Okay, yeah.
Okay. This is the people of the state of Michigan versus JaVale Hicks, case number 2258961. Mr. Hicks is charged with 1 count of police officer assaulting, resisting, and or obstructing. Today is the day set for a probable cause conference appearances.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
Good morning, Your Honor. Kenneth Waldhorn on behalf of Mr. JaVale Hicks, P37819. If I may, Your Honor.
Yeah, please, go ahead.
As I indicated earlier off the record, we are prepared to waive Mr. Hicks's presence for today's purposes. I did speak with him yesterday. I also indicated to the court that I have yet to receive discovery despite the request on the website. So ultimately, we're asking for an adjourned PCC.
Okay, Mr. Decker, you have any insight on that?
Yeah, Your Honor, from what we understand, there's been some kind of a reassignment between lieutenants. So we are actually we do not have discovery yet either. The people absolutely agree to and encourage the idea of moving the PCC to a later date.
Okay, Attorney Waldhorn, do you want to still set an exam date? Just have in place so we'll get tomorrow out.
I'm sorry, it broke up. Could you repeat that, please?
I will adjourn the PCC today, but do you also want to set an exam date as well with the hope that you have discovery?
No, I think we need just to adjourn the PCC, and if upon my review of that, an exam is called for, well, we'll take care of it then.
Okay, I'm just trying to make sure you get on the calendar as soon as possible if you want to hold.
Well, that's appreciated.
Yep, I will adjourn it out 1 week.
1 week. That would be until
March 2nd?
March 2nd. That's fine.
Okay, does 8:45 work?
I guess, yes, it's by Zoom, so it shouldn't be a problem.
Okay, all right, I will see you then.
Thank you much.
You're welcome, have a good day.
You too.
Attorney Taylor Coleman, good morning.
Good morning, Your Honor.
How are you?
I'm on Massey,
Yes.
but my car is frozen shut.
Sorry, what did that hear the last part?
My car, I'm in a rental car, which I objected to when I got it. It's a Challenger, and the windows suck open and suck close when you open the door, and the doors and windows are frozen shut. I can't get in. I can't. Yeah, I have no transportation. So I'm asking for a new exam date.
Looking for a new exam date, okay.
Have you spoken to your client yet?
They're down there, Your Honor. My understanding, they are at 36th District.
Yeah, I was wondering if you talked to him to let him know that you won't be able to make it.
I haven't, trying to fix the problem this morning. I did not call them back, but I can text them right now. They were aware that I would be requesting an adjournment though, because I do not have the video in this matter.
Okay, this is the people of the state of Michigan versus LaShawn Massey, 2161451. Mr. Massey is charged with 1 count of weapons carrying concealed today as the day set for examination. Appearances.
Good morning, Your Honor. Eric Decker, P85931 for the people.
Good morning, Your Honor. Deletion Taylor Coleman, P56278. LaShawn Massey. I do apologize for my in-person appearance.
And Mr. Massey, you said it's in the hallway. No. Okay, so Attorney Taylor Coleman, you said 2 things. Your car, you can't get here, and then also you don't have discovery.
I don't have video discovery. I've received the paper discovery, but I have not been able to access any video discovery. I don't even know if I received it, because what I received is what I sent to my client.
Your Honor, this is the first I've heard of this, so I can't speak to it. I believe it was sent, and Mr. Kirker is checking that out right now. I don't know. In the event that there's digital discovery that she does not have, we could probably get it taken care of by today or tomorrow. But again,
let's set it for next week.
But of course, yeah, this is again, this is the first I've heard of it. I don't know if it was sent or not. I'm gonna guess that it was.
Can we set it for next week?
Can you do March 1st at 9:30?
No. If we could do 11.
Oh, she said 11. It works. We'll do 11, March 1st at 11 o'clock.
Thank you, Your Honor.
What's that?
March 1st at 11.
In person. And I do apologize, Mr. Massey. Please give me a call.
All right, anything else?
Nothing further. Have a safe, blessed day.
You as well, thank you.
Thank you.
I guess, Your Honor, we're confirming it was sent, but we're still on the record.
Okay.
Your Honor, I'm standing in for Alyssa Segura on Mr. Malcolm Taylor Hatch. There's 2 cases he's waiting.
Okay, all right. Okay, we are on the record as the people of the state of Michigan versus Malcolm Thomas Taylor Hatchett, case number 2355195. Mr. Taylor Hatchett is charged with 1 count of weapons carrying concealed. This is a felony commission with motor vehicle adult advisory. Mr. Taylor Hatchett is also charged on case 2257277 with count 1, weapons carrying concealed, count 2, operating a license suspended, revoked, and or denied, with a second or subsequent offense notice, also with a commission of a felony with a motor vehicle advisory. Today is date set for preliminary examination for both matters. Appearances.
Alexander Kirker on behalf of the people, P86282.
May it please this honorable court, William Notes, P42796 of the Neighborhood Defender Service of Detroit, standing in for Ms. Alyssa Segura on behalf of Mr. Malcolm Taylor Hatchett, doing so with Mr. Taylor Hatchett's permission. Taylor Hatchett, please tell the court your name.
Morning, my name is Malcolm Taylor Hatchett.
Good morning, sir. All right, correct, do you want me to swear your honor? Unless you want to.
Excuse me.
You want to question your client, or you want me to?
No, he's agreed, he's waiving, so I would just expect that you would ask the 4 questions that are required of a waiver.
Okay, any objection from the people?
No objection.
Mr. Taylor Hatch, I'm going to ask you actually a few words before questions. Is it your wish to waive your preliminary examination today?
Yes, ma'am.
Do you understand that you have a right to exam?
Yes, ma'am.
And that if you were to hold or demand your exam today, that people will have to show that the probable cause standard, which is a lower standard than the beyond a reasonable doubt standard, they will have to show at the lower standards that the charges that I read off were committed in the city of Detroit, that you probably committed those crimes. You understand that?
Yes.
And that by waiving your exam today, the people do not have to prove it.
Yes, ma'am.
And knowing that information, you still wish to waive your exams.
Yes, Your Honor.
Okay. It does not, you're not giving up your right to trial. I know some people are confused about that. You still have a right to trial, okay?
Yes.
Did anyone force you or threaten you to waive your exam today? Okay. Did anyone promise you anything?
No, Your Honor.
Okay. I find your waivers to be free, voluntarily, and understandably given on both cases. So I will have you bound over to 3rd Circuit Court, Frank Murphy Hall of Justice, for an arraignment on the information, March 9th at 9 o'clock a.m. That calendar doesn't have March. March 9th is 2 weeks from today. Anything else?
Thank you, Your Honor.
Thank you. Have a good night.
You too. Your Honor, may I approach?
Oh, thank you. Yeah. And I have my notes here. I have all of this stuff. That's all right. Very good. It's all right.
I'll see you next time.
All right, have a good rest of the day. The lady wants to define.
I'm back, Judge.
Okay, let's see, your client, I forgot that, Mr. Bingham, correct?
Correct.
Oh, yes, Mr. Bingham's here. All right, give me one moment, let me write some notes from that part of his case. Okay. Okay. Attorney Anderson, your client's file is next door, so we're gonna grab his files and then call the case. Call the case.
Thank you.
Mr. It says Shayla Jones. Can you unmute your device? There you go. So what's your name?
My name is Travis Jones.
Okay, what matter do you have today, Mr. Jones?
I got stopped by the police, without insurance and my license suspended.
Okay, so you should be in courtroom 332. I put the information on the screen. You can head over there to Judge Larry Williams' courtroom, okay?
Okay, 332, Larry
You got it?
Williams.
Yes, do you know how to get there or do you need help?
I'll get my daughter to do it. But thank you, Your Honor.
Well,
332.
we're on the record as the people of the state of Michigan versus Alverno Ian Bingham, case 2355511. On this case, Mr. Bingham is charged with count 1, motor vehicle unlawful driving away of an automobile. Count 2, stolen property, receiving and concealing a motor vehicle. Mr. Bingham is also charged on case 2260806 with the following count for motor vehicle unlawful driving away with a habitual offender fourth offense notice. For probable cause appearances.
Morning, Your Honor, Dr. PA 5931 for the people.
Good morning, Your Honor. James Anderson, P 31302 on behalf of Mr. Bingham on both files.
And Mr. Bingham, can you state your name loud for the record, please?
Alverno Bingham.
Say it one more time.
Alverno Bingham.
Thank you. Good morning.
Your Honor, I have spoken with Mr. Bingham regarding whether or not he wants to have an exam on both of those files, and he indicates that he does want to have a preliminary examination. So we'll be asking for a date, hopefully March 2nd.
Let's see here. Okay, so how about 10 o'clock?
March 2nd, 10 o'clock is fine.
Okay. Mr. Bingham, I need you guys to be back here first. March 2nd, you have a question?
Yes, I had to go to my tether officer on March 2nd. He want me, I got a tether and he want me to show up at roll up on Gardner March 2nd.
You have a tether on this case?
No, I got a tether on my leg and I'm just.
For this case?
No, and actually, no, I supposed to go see him at parole office on March 2nd.
Oh, you said parole?
Yes.
Sorry, okay. What time?
I think it said 9 o'clock.
Okay, so when you get done, just stop. So I'm not going to enter a warrant or a case. So tell tell them that you have an exam set at 36th District Court and the judge is waiting.
All right.
And obviously, we're here.
And another thing, man, the judge at BDC said he wanted a tether on me, but I got a tether already. Do I still have to put on another tether? I mean, okay, because he did say he wanted me on tether and I can't leave unless I work, but I'm on a tether already with department, with parole to like, to next month. So I'm wondering, can I just keep this tether on until I get this off?
Yeah, I was gonna remove your tether if it was for this case anyway.
Okay.
No. Anything else?
So I can get the tether removed?
If it's for these cases.
Oh,
yes.
okay, okay.
But you said you have parole.
Yeah,
tether attached to that case.
it's for parole.
Yeah, I can handle that case, but for these cases, no tether.
All right.
Okay?
All right.
All right, I will see you on March 2nd, 10 o'clock.
Okay.
Or whenever you get done with parole.
All right.
Thank you, Judge.
You're welcome.
All right.
He doesn't have a- Oh, it does say tell it.
Yeah, yeah.
All right.
Yeah, she, lives in, how'd you know what that happened? Yep. It's down to- then we'll think about what's going on with the rest of the subs. Yeah, officer, check the. Alhadi, yeah. Alhadi, we have, officer just checked that.
That's,
Yeah. PCC.
I don't have any information for That's Sabree.
What's your name? What's your name, sir?
Earl McGlory. Let me cut this down.
Okay.
My name is Earl McGlory, Judge.
Good morning.
Good morning.
What are you calling in for today?
Earl McGlory.
What are you calling in for? What matter do you have? What type of matter?
Oh, I'm management with Pequot Square.
Okay, so my brother is the one, is the judge on landlord, this is the felony guy.
Hello?
Did you hear what I said?
No, I didn't.
Okay, my brother
course,
is,
you know, I'd like to
my
confirm
brother
that
is
myself
Adam
with
Sabree,
defense
Judge
counsel.
Sabree, Adam Sabree. 436, this is 438 with
Just
Aliyah
when
Sabree, this is the felony
counsel's
guy.
here.
So people keep getting confused. So you should be in 436 with Judge Adam Sabree.
Adam Sabree. Okay, thank you.
You're welcome.
You got the wrong one. Oh, it's her brother.
Age of my first name. Age Sabree.
Madam Clerk?
Good morning, council. How can I help you?
Judge, and I
Good
hate
morning.
to be,
Hi, good morning.
good morning. I hate to be so much trouble with your docket. I do. So, I was in your court yesterday. So I get home and I'm getting ready to go to Grand Rapids. Grand Rapids sent the email and they called. They closed their courthouse down. I guess it's really, really bad up there. So I'm actually off from the trial today and tomorrow. And they want us to come back Monday. The first thing I did was think about your case because we set it for Monday. But I am available tomorrow. And I know that this is last minute and your prosecutor has to organize everything. Can we do Mr. Robinson preliminary exam tomorrow?
The judge stepped out for a moment and I'll mention to her when she comes back. Madam
Okay.
Counsel, prosecutors.
Just see, I just wait because when I got home, after I left the court, I got an email. They closed the courthouse in Grand Rapids. I think it's like the first time they did it in like 100 years or something, besides COVID. Okay, I'm just on Zoom.
Attorney Marable?
Yes.
Can you call Ms. Boyd to get a date on 965-2406?
Okay, hold on. Let me get a pen.
Okay.
So that's the prosecutor name? That's the prosecutor number?
No, that's the clerk's number.
Okay. So what's the number?
965. 2406.
2406. I'm calling right now. Thank you.
Okay. Who's handling El Hadi? Mr. Kirk, are you doing El Hadi?
I understand.
Okay. Ms. Marable was calling about a date, so this is it. No, you come on up. Oh. Okay, we are on the record as the people of the state of Michigan versus Abu Hamra Mohammed Al-Hadi, 2260530. Mr. Al-Hadi is charged with one count of motor vehicle operating a chop shop. They set for a preliminary examination. Appearances.
Alexander Kirker on behalf of the people, 86282.
Morning, Your Honor. Attorney Luke Derringer, P85677, appearing on behalf of defendant Amr Al-Hadi, who is standing to my right. Mr. Al-Hadi, could you please state your name loudly and clearly for the record?
Amr Al-Hadi.
And is it my understanding that your client wishes to waive exam today?
That is correct. I've advised him of his rights to a preliminary examination. He has elected to waive that examination today and request this matter be found over to circuit court.
The objection from the people?
No objection, Your Honor.
Okay, just a couple questions I'm gonna ask your client, okay? Is it correct that you wish to waive your exam today?
Yes, Your Honor.
You understand you have a right to an exam?
Yes, Your Honor.
And that if you were to hold and demand your exam today, people would have to prove at the probable cause standard, much lower, but still a standard, that the charge that I just read off was committed in the city of Detroit, that crime was committed in the city of Detroit, that you probably committed that crime. You understand that?
Yes, sir. Yes, sir.
And that by waiving your exam today, the people don't have to prove anything today.
Yes, Your Honor.
Okay, knowing that information, you wish to still waive your exam.
Yes, Your Honor.
Did anyone force you or threaten you to waive your exam today?
No, Your Honor.
Did anyone promise you anything?
No, Your Honor.
Okay, I find your waiver to be freely, understandingly, and voluntarily given, so I will have you bound over to Third Circuit Court, Frederick Hall of Justice for March 9th for your arraignment on the information at 9 o'clock. Okay?
Your Honor, do you know if that will be via Zoom or in person?
I think they're doing different things.
Okay, thank you.
I don't want to commit to an answer.
Thank you.
Have a good one. Tanya Mary, good morning.
Good morning, I'm sorry.
So you're here along Mr. Arnold, was he able to get admitted today?
I believe so. I don't know if Nancy showed up on the Zoom this morning. I had talked to the guy that was checking him in at the forensic center yesterday around 1, and he wasn't there yet. So I can check with his dad to see if he made it in there. But I wanted to Zoom in as quickly as possible. I had a couple other courts I had to be in this morning.
Your Honor, we do have, that he did arrive for admission on, February 22nd. And he's currently residing at the Center for Forensic Psychiatry.
Oh, good, yes.
Okay, so we said 60 days about right for coming back to court.
Okay, sounds good.
Amenable to 60 to 90.
Okay, we'll be hopeful.
Yes.
So for April 23rd,
What was the date?
Oh, April 24th.
April 24th. Okay.
At 9 o'clock.
Thank you. All right, thank you.
You're welcome. Have a good one.
You too.
Did you? Yep.
Oh, awesome.
Okay, we're on the record, this is the people of the state of Michigan versus Aaron Gillum, case 2355052. Mr. Gillum is charged with count one, breaking and entering a building with intent, count two, larceny in the building. Today's day set for a probable cause conference. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Alex Petro, neighborhood defender, Detroit 85948, appearing on behalf of Mr. Gill.
And Attorney Cho, is it my understanding that you're having difficulty finding your client?
Yes, Your Honor, we were recently appointed to him. There is no contact information in our file. I have asked my investigators to locate a number so that I can get in contact with my client. I've requested a couple weeks adjournment to try and get in contact with him.
Anything you people?
Nothing.
Has discovery been sent?
Your Honor, we have paper discovery. I do not believe we have digital.
Okay, well, we have some time. I will grant the 2-week adjournment to try to find your client. That would be March 9th. Does that work?
I believe that'll be perfect, Your Honor.
Okay. Do 8:30.
We'll be there 8:30.
Yep, we did.
We're gonna do it. Stay safe.
State of Michigan versus Lawrence Alexander Beasley. Case number 2260951. Mr. Beasley is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, ammunition, possession by a felon. Count 3, weapons, stony firearm. Count 4, weapons, stony firearm. This is a habitual offender's fourth offense notice. Today set for a preliminary examination. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. My name is Daniel Wazak. My bar number is P35225. I stand with my client who's immediately to my right. Sir, will you tell the judge your name, please?
My name is Lawrence Beasley.
Good morning.
Good morning.
Okay, any preliminary matters?
Motion is to sequester witnesses. Judge, defense has no witnesses for this morning.
Okay.
And no one else is here.
Okay. For anyone who is watching on YouTube who may be a witness on this case, it's now time for you to log off. Is there an officer in charge of this case that we sit in here?
I'm not sure.
Okay.
If the officer in charge does.
I wouldn't object to the officer in charge.
Okay, so there's no one in the gallery. With that, anything else?
Your Honor, at this time, the people are going to next to MCL 76611B1B to certify a copy of the defendant's previous felony charge with armed robbery.
We would stipulate to that, Judge. We're going to object to it.
Okay, all right. That will be a minute. Anything else?
Yes, Judge, I believe there's also a stipulation that my client has not had his gun rights restored since that conviction.
Right.
Yeah, Roger.
Sure. Okay, call your first witness.
This time, the people would call Officer Lisa Latu. Lisa Latu.
We're telling you how to. Have a seat, make sure you speak up in the microphone. Whenever you're ready to start.
Good morning. Could you please restate your name for the record?
Lisa Latu.
Are you currently employed?
Yes.
Where are you currently employed?
Detroit Police Department.
And in what capacity are you employed?
Police officer.
How long have you been employed as a police officer?
4 years.
Were you employed as a police officer on July 21st, 2022?
Yes.
Did you in fact work on that date?
Yes.
Were you by yourself or with a partner?
I was a partner.
What is your partner to you?
Officer Jenner.
Were you in full or modified uniform?
Class C uniform.
Could you describe that uniform?
Yeah. Green pants, a black vest that says police on it, displays badge, and a tag.
And did your duties as a police officer take you to an area at or near 18949 Crest Street?
Yes.
That in the city of Detroit?
Yes.
County of Wayne?
Yes.
And what brought you to that area?
We are assisting Agent Hamilton with MDOC compliance check.
And what is an MDOC compliance check?
Yeah, so when a person is on parole or information, we are there just to confirm that they are in terms of their in compliance, their parole conditions.
And what does this entail? Checking to see if there's compliance with parole conditions.
So that leads us to their room where we're allowed to check if
They're in compliance, check for weapons. Anything that would not be in compliance with the terms.
And what happened when you arrived at this location?
Morris Beasley opened the door for us and stated that Mr. Beasley was.
You're not going to object to possible hearsay.
We established in this week for who Lori Beasley is.
And who is Lori Beasley?
She identified herself as the mother of Morris Beasley.
I'll let that one slide, Judge.
Okay.
And what happened when you entered the home?
We were directed to the basement for Mr. Beasley's room.
Excuse me, Judge, I'm going to object. That's a fact, not an evidence that it was Mr. Beasley's room. That's never been established. I mean, she may testify she was directed to a room.
And later on established it too.
Correct.
At this point, there's no testimony there.
Thank you, Judge.
So you were directed to a room. Right. And what happened when you entered this room? Actually, where was this room?
In the basement.
And what happened when you entered the basement?
I was directed by Agent Hamilton, search the room, to see if I found any firearms, weapons, ammunition.
And were you able to find any of these items?
Yes.
And can you describe what items you found?
Yes, so the first thing I found was underneath the bed, was a drum magazine.
Can you describe what you mean by a drum magazine?
Yes, it's a magazine for a firearm, contain multiple rounds of ammunition inside of it.
Did you find anything else?
Yes, so I continued searching, and then there was a futon across from the bed. Underneath the futon was a black backpack. Inside the backpack was a loaded AK-47 style firearm.
You say AK-47 style. Can you describe what you mean?
Yeah, it's like a pistol, however, it's pretty large, it's not a handgun. Draco style is also what it's called.
Find anything else inside this backpack?
Yeah, there was a second loaded magazine inside of the backpack.
And have you had any previous contact with the person who you were conducting a compliance check on?
No.
Were these items placed into evidence?
Yes,
Do you recall the evidence tag number?
not offhand, I have to check.
Reviewing your report, refresh your recollection?
Yes.
May I ask what page she's reviewing, please?
Oh, package. Do you recall the evidence tag numbers?
Yeah,
What are those evidence tag numbers?
679-811-5 through 679-811-7.
No further questions, Your Honor.
Sorry, Judge, just a moment, please.
Okay.
Good morning. Is it Officer Lachuf?
Yes.
Thank you. If I ask you any questions that you don't understand or don't know the answer to, just say so. I'll try and rephrase it. And it's fine to say, I don't know. if you don't know. Do you know if anyone else was in the house when you were conducting your compliance check? Other than Mrs. Beasley? And the officers who you were assisting?
Besides other officers, I don't recall anyone else besides Mr. Beasley. I know there was no one else in the basement at that time.
During your compliance check, did you ever see Lawrence Beasley?
I did not.
Did you ever see Lawrence Beasley that day ever handle a handgun of any kind?
No.
Did you ever see him handle any magazines? Ammunition?
No.
Do you recall how many beds are in the room you were searching?
There was one bed.
And there was also a futon, correct? How many other rooms are in that basement?
Don't recall.
Is it,
I know there's a larger area, and then that bedroom was pretty close to the stairs as soon as you walk down to the left.
but you didn't see another bedroom down in the basement when you were there?
I don't recall another bedroom.
All right. While you were conducting your compliance check, did you see anyone go into or come out of that room?
Besides officers, no.
Do you know prior to your compliance check when that room was entered before you got there at all?
I would not know that.
Would you know if anyone immediately prior to your compliance check actually had entered that room? You would have no way of knowing that, correct? And forgive me if I'm repeating, you've never done a compliance check at that location before, have you?
At that location, no.
Thank you. Judge, I think I'm gonna finish for now.
Okay, redirect.
No, you're
Depends on how you would.
We're not presenting witnesses, Judge, I will have a motion.
Your Honor, this time the case was signed over on all counts of the count one, weapons, firearms, possession by the felon, count two, weapons, ammunition, possession by the felon, count three, weapons, felony, firearm, and count four, weapons, felony, firearm. As we heard from the witness, directed to conduct a compliance check for parolee. Conducting the compliance check, multiple items that were not in compliance with the conditions of parole were discovered. Those items included a drum magazine, a loaded magazine in a black backpack, and an AK-47 style handgun. Those items were placed on evidence, so people were notified of it.
Your Honor, with all due respect to the people's attorney, this is clearly a case of insufficient evidence. There's nothing to tie, on this record, there's nothing to tie my client to any room in the basement. There's nothing to say who went in, who went out, when they did that, when was the last time my client was there. There were weapons in a house, in a room, where my client was not present. So I think the element of possession by my client is not met here. That element is just not present. So I'm going to ask you to dismiss the case, Judge.
No.
Quick case, we heard from Officer Lisa Latu, who was directed to help Agent Hamilton with the MDOC compliance check. He was directed to check room at 18949 Crest in the city of Detroit. Directed to a room in the basement. which Ms. Beasley answered the door of that location, who is, according to Officer Latu, the defendant's mother. While she was in the basement in that room, she found several items, a drum magazine under the bed, and under the futon, a black backpack, AK-47 style firearm, Draco, second loaded magazine in the backpack, placed on evidence. So there is an issue here with possession, especially since Mr. Beasley was not home or present, or I don't know if that is his home because there was no testimony. All we have is Officer Latu saying that she was directed to help with MDLC compliance check. However, I do believe there's insufficient evidence to show that Mr. Beasley lived there and was in possession of those items. Very well could have been, but the record does not show that. So I will dismiss all counts without prejudice. You were off the record. Mr. Smith, good morning.
Good morning.
Drayshawn Smith.
Good morning.
Oh, that's him? I didn't think he was in custody.
No, sir.
Not in custody.
I'm sorry?
He's not in custody.
He's not?
Mr. Smith, can you hear me?
Yes.
Hmm.
You hear me?
Can you
Can you
say
hear me?
something?
Can you hear me?
Okay, we can't hear you.
All right.
Try now.
Can you hear me?
Yes, we can hear you now.
All right.
So you have the exam today. I guess unless your attorney told you otherwise, you should be here in person.
Judge, I believe a message is with him for, he hasn't responded to my phone calls. Got two numbers, enough messages that both numbers are texted. Can we get any date?
Yeah, Mr. Smith, you were supposed to be here in person.
No one ever told me. Last time we talked, I know he pushed the days back to the 23rd. Nobody never said nothing about I had to say.
I know I make a special effort to say every time when I set an exam date that it's in person.
I didn't know that.
Your Honor, we have a complaint with this here. We have the people that must have this.
Well, Judge, I believe this is going to be a waiver. It's just,
Do a waiver.
Let's call it. This is the people of the state of Michigan versus Drayshawn Lamar Smith, case 2355281. Mr. Smith is charged with one count of assault with a dangerous weapon, felonious assault. Today is the date set for a preliminary examination appearances.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
good morning, Your Honor. Evan Callahan, P30561 on behalf of the defendant.
Mr. Smith, can you state your name for the record, please?
Drayshawn Lamar Smith.
Okay, so I believe there was a misunderstanding on Mr. Smith's part, thought that he could zoom in. Next, you said you're planning witnesses here.
Yes, Your Honor.
Attorney Callahan, you're asking for an adjournment.
Yes.
People requested cases.
Mr. Smith is virtually present. I'm not going to intercede this. My question to you, Attorney Callahan, do you want to speak to your client before you send an adjournment? Because you said that it may be a waiver.
I need to talk to him about the circumstances of this case. I believe I'm going to recommend that he waive the exam.
Right. you have time to speak to him, if we go off the record and handle a case, you come back on and let us know if you do the waiver today, or if you want to set it for another day.
Do it tomorrow.
That's fine. And if you do the waiver, he can zoom back in.
Okay.
I don't need it in person if he's okay with it. If you're okay with Zoom.
I got two other matters tomorrow morning, so. I could do this first thing. Would you have the defendant please give me his phone number right now so I can talk to him?
Mr. Smith, can you please provide your phone number?
What's my 419? That's the area code. 790-1281.
Let me make sure that my complaining witness is available tomorrow.
I'm gonna talk to him, maybe we can do this today.
Okay.
Oh, wait.
Mr. Smith, your attorney is about to call you, okay? So log off, answer the phone so they can talk to you, so that you can discuss with him how you're gonna move forward, okay?
Okay, the number again is 419-790-1281.
Yes, sir.
All right, I'll call you in 2 minutes, Judge. I'll be about 10 minutes.
Okay, we're here.
All right.
Attorney Richards, good morning.
Good morning, Judge. I had Harvey Arnold, who we got the order for him to get the tether off yesterday so that he could get a bed. And he did, in fact, report to the forensic center.
Okay, so we set it out for 60 days for April 24th with the hope that you have some information.
Okay, sounds good.
9 o'clock, April 24th.
All right, thank you.
Welcome, have a good day.
You too.
Mr. Hicks.
Yes.
Good morning.
Good morning.
Case was already taken care of this morning at 8:30.
Okay, I'm so sorry. I know he told me 8:32. I woke up late. I just literally woke up.
Okay, why? I mean, you have court date. This is a felony matter. I could have easily issued a warrant.
You said what?
I could have easily issued a warrant for you. Like what? Why didn't you wake up? This is a pretty important matter.
I know. I had set an alarm and everything. I didn't think nothing about it. I'm not gonna lie. It literally just slipped my mind.
Yeah, please don't lie.
I talked to my lawyer yesterday and everything. He told me 8:32. I don't know what happened.
Okay, so call your lawyer for your new date. I don't have your files already. With the files
Okay.
of cases that are done for the day. Call your attorney and get the time and date and be on time next time, okay?
Okay, thank you.
Yeah, I am a wordsmith.
So, I'll try to be, I mean, like,
This is a recall, people of the state of Michigan versus Drayshawn Lamar Smith appearances.
Morning, Your Honor, Eric Decker, P8593, the people.
Good morning, Your Honor. Evan Callahan, P30564. Appearing on behalf of the defendant who appears via Zoom.
And Mr. Smith, can you state your name again for the record, please?
Drayshawn Lamar Smith.
Thank you. And Attorney Callahan, you had the opportunity to speak to your client out in the hallway on the phone.
Yes, Your Honor. At this time, today is the date and time set for preliminary examination in this cause. Having conferred with the defendant regarding his rights to that exam, Judge, the defendant has opted to waive his right to an exam.
Mr. Smith, is that correct?
Yes.
Okay. I'm gonna ask you a couple of questions, okay?
Okay.
You understand you have a right to a preliminary examination?
Yes.
And you understand that if you were to hold it today, the people will have to show or prove at the probable cause standard, which is a much lower standard, that the charge that I read off, felonious assault, was committed in the city of Detroit, that you probably committed that crime. You understand that?
Yes.
That by waiving your exam today, the people do not have to prove or call any witnesses. You understand that?
Yes.
And knowing that information, do you still wish to waive your exam?
Yes.
Did anyone threaten you or force you to waive your exam today?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given, so I will have you bound over. But before I have you bound over, for the record, Mr. Decker, do you have an objection?
No, Your Honor.
Okay, I'll have you bound over, Mr. Smith, to Frank Murphy Hall of Justice, that's Third Circuit, for an arraignment on the information, March 9th at 9 o'clock. Anything else from either party?
No, Your Honor.
Okay.
Thank you, Your Honor.
And I guess Attorney Callahan is correct that your client consents to doing the waiver on Zoom.
Yes, Your Honor.
Okay,
Thank you.
just covering all my bases.
I'll be in touch, Mr. Smith.
All right.
Got my number. Don't hesitate to call me this weekend.
All right. I am.
All right, Mr. Smith, you can log off. Have a good rest of your day.
You too.
Thank you. Oh, you're welcome. Thank you for taking the time to talk. Okay, back to you.
Yes, sir.
Like, I haven't heard anything on the red case. Okay. Close officers that is done. For Smith. Okay. So that way. And what your client is next.
I'm sorry.
What your client is next. Okay.
Real touchy. Touchy.
Yeah.
Not a pleasant person to be around.
Okay, I got you. Jerseys, okay.
Ellie Muriel Anderson, case number 2258832. Anderson is charged with 1 count of assault with dangerous weapons, dwelling assault. The case of offense, second offense notice. They set for a preliminary examination. Appearances.
Alexander Chris on behalf of the people, P 86282.
And good morning, Your Honor. May it please this honorable court and your staff, Melvin Houston, P number 36280, appearing on behalf of Ms. Kelly Anderson, who is present in the courtroom, standing immediately behind me to my right.
And Ms. Anderson, can you state your full name for the record, please?
Kelly Muriel Anderson.
I did that last time too. Good work. Okay, are all parties ready to proceed?
People are, Your Honor.
As is the defense, Your Honor.
Okay, any preliminary matters?
None from the people, Your Honor.
Let me just ask for sequestration of all witnesses, Your Honor, with the exception being the officer in charge.
He's got, he's the attorney, correct?
Yes.
You don't have to leave. If you're not on the case.
Yeah, you're not on the case.
No, I'm not.
No, you can stay in the room. Okay, and for the record,
We're not calling them.
yeah, I would hope not.
Yeah.
Usually. So for anyone who's watching on YouTube, and you may be a witness to this case, now is your time to log off. And for everyone in the courtroom, for the record, there's no one other than attorneys, staff, and defendant, and both the prosecutor and defense attorney. So there's no need to have anyone leave the courtroom. Anything else preliminary?
Okay, for the defense.
Okay. You call your witness, or your first witness, Mr. Hurst?
Your Honor, at this time, people call Myers, right?
You swear to tell the truth, the whole truth, and nothing. Okay, I have a seat right here, and you can hold the microphone if it's easier for you, just make sure you speak up, okay? Whenever you're ready.
Good morning. Could you please restate your name for the record?
Myron C. Wright.
And I want to take you back to the date of May 18th, 2022. Do you remember that day?
Yes.
Were you at or near the location of 1152 Fulton Street?
Yes.
Is that in the city of Detroit,
Yes.
county of Wayne?
Yes.
And what brought you to that location?
It's my place as employee.
And what do you do there as part of your employment?
I'm a maintenance supervisor.
And were you working as a maintenance supervisor on that day?
Yes.
And what were you doing at that location on it?
Okay. Filling work orders. At that time, I was talking to tenant. That I worked in.
And did anything happen that brings you into court today?
Yes.
And what happened?
I was talking to the tenant.
Mr. Wright, can you put a microphone down? Thank you.
While I was talking to one of my tenants that stays in the building, 1160, which is right next door to 1152. He was discussing some of the things, issues he had.
Objection, Your Honor, hearsay.
Acknowledged, Your Honor. You can say that you were talking to a tenant, but not specifically what the tenant said.
I was talking to a tenant. While I was talking to the tenant, Kelly Anderson came over to where we was talking.
And when you say Miss Kelly Anderson, is there anyone present in the courtroom today who you came into contact with on that day?
Yes.
Could you please identify that person and point out an article of clothing that they are wearing?
He said he was there. You asked him about the fur coat.
Not on the record, like the identification of the defendants.
So reflected.
So you said you came into contact with the defendants?
Yes.
And how did you come into contact?
She came over and started cussing me out, calling me out my name,
And by cussing you out, what do you mean?
calling me MFB, whatever else came out of her mouth. So I just ignored it. She kept on. And all of a sudden, she walks over and picks up this brick.
And could you describe the brick?
It's a masonry brick, you know, the building brick. And it's not a whole brick, but it's a piece of it. And threw it at me.
And did you see the defendant throw it at you?
Yes, I did.
And did the brick hit you?
No, it didn't.
Where did the brick land?
About 2 feet on the right side.
Did you fear that the defendant would hit you with the brick?
Can't really close because when I looked at it, down at it, I saw it coming towards me again to get it to retrieve it. So I grabbed it myself.
And was this before the defendant could grab it?
Yes.
Objection, Your Honor, speculation.
Assuming yes, that the defendant. Yes. just rephrase the question.
What did the defendant do after she threw the brick at you?
She rushed towards where the brick landed.
Did she reach down at all for the brick?
No, because I picked it up before.
And what happened after that?
Cussing me out. So, the tenant that I was talking to, told him, we'll take care of this matter later. Went to the office and wrote to report on the incident that happened.
And you had problems with the defendant in the past?
Yes.
And what were those problems?
Objection as to relevance, Your Honor.
Just for motivation for this incident.
Pretty broad question.
Were you worried when the brick was thrown at you that you would be hurt?
Yes, because when they hit me. Yes.
You said it again, I can barely hear.
Yes, if it, you know, if it made contact with them, my leg, that information that came, yes, it could be. It was up here.
I have no further questions.
Thank you, Your Honor. Mr. Wright, I'm going to ask you some questions as well, if my brother counsel did. If I ask you questions you don't understand, let me know and I'll try and straighten it out for you. Is that fair enough?
Yes.
You indicated that you were working as a maintenance supervisor at this address, 1152 Home Street, is that correct?
Correct.
That's it's part of an apartment complex known as the Don Juan Apartment, is that true?
Yes.
Does that facility have green light capability?
Yes.
And was, to your knowledge, was that green light capability working that day?
I believe it was.
Now, this has been a while ago. You indicated it was May 18th, 2022, right?
Correct.
Do you know whether or not the video recording of that incident was retrieved and saved?
But,
Now, you indicated that, let me back up. What time of day was this?
probably about noon. Probably about noon.
Are you sure about the time?
No, I'm not sure.
Could it have been later in the day?
Possibly.
In any event, at the time that you had, you reported having some sort of discussion with one of the neighbors to my client, Ms. Anderson, correct? At the time, you indicated that you were initially involved in the discussion with the neighbors of my client on Ocean Street, is that correct?
Correct.
Okay. And when Ms. Anderson came to the area where you and this individual were talking, how far away from you and this individual was it?
Let's say probably about 5 or 6 feet.
Was Ms. Anderson directing her conversation towards you or towards the neighbor?
Towards me.
Okay. What was the nature of the discussion that you were having with Ms. Anderson?
I wasn't having a discussion.
You were not exchanging any words with her at all?
Not at that, no.
And what was she complaining about?
Ms. Anderson doesn't need reason to complain. Every time I went to work in our house, I completed the work, kind with you, you know, for you, you know, she's kind of for you.
Mr. Wright. Hold the microphone to your right. Pick it up.
So you can't recall the specifics as to what it was Ms. Peterson was complaining about on this date and at that time?
There was no complaint. She wasn't playing, she was just cussing me out.
For no reason.
No reason.
Mr. Wright, isn't it true that Ms. Anderson was complaining to you about one of your visits to her apartment where she alleged that you in effect went to her refrigerator? Do you recall that?
How would I go to her refrigerator? No.
This
no,
ain't, I ask questions, you give answers.
No, I did not go to her refrigerator.
So you don't recall that discussion taking place on this day, May 18th, 2022?
No.
So it's your testimony that she just came over and just started cussing for no reason at all?
Yes.
You didn't indicate that she went and picked up a brick. How far away from you did she go to retrieve this brick? Or at least a portion of the brick?
It was probably maybe about 2 feet from her.
Was she on the sidewalk?
Yes.
Brick was located on the sidewalk on Fulton Street.
Yes.
How large was this portion of brick that you described? What would you say, Council? 4 by 4? About 4 inches by 4 inches?
Yes.
Okay. And how thick was it? About the same thickness?
It was about 2 inches.
Okay. 2 inches thick, so 4 by 4 by 2.
Yes.
And how far away was she from you when she proceeded to throw this brick toward you, as you mentioned?
Approximately 5 feet.
She was 5 feet away, and still the brick didn't reach you, isn't that true?
It went past me.
Pass you by how many, how much of the distance?
Probably about 2 feet.
And I think you testified that it landed on your maintenance bag, is that correct?
Yes.
Did it strike your maintenance bag?
Yes, it is.
As the brick passed you, what was its altitude? By that I mean, was it?
Oh, like 100%. It was probably about in between my waist and knee.
Your waist and knee?
Yes.
And I think you indicated you, after this conversation, you went to the office to write up some complaints.
Yes.
Do you recall having a discussion with one of the Detroit police officers named Sexton?
Name sounds familiar.
Was that discussion with the police officer on that day?
I don't remember.
Did you summons the police officer that day?
I think I did. I think I did call the police.
Now, in order to retrieve that brick, Ms. Anderson had to go past you, is that correct?
Yes.
All right. You indicated that you never gave her the opportunity because you retrieved it yourself.
Yes.
Her complaints to you, the cussing and fussing continued while you retrieved the brick?
I didn't pay attention to what she was saying.
Did you say anything to her in response after the brick was thrown?
Yes, I did.
What did you say?
That's the way she prayed.
How did she respond to that?
She kept cussing. Called me out of the name.
When did you leave the scene?
Well, maybe 5 minutes later.
Was Miss Anderson still at the scene?
Yes, she was still out there on the left.
Was your neighbor still out there as well?
Yes, he was.
What is the neighbor's name?
I think his first name was Rodney.
And I think you gave an address, that address being 1158.
No, he stays in 1150, no, 1160. Pardon me, 402.
Is he still a resident of that facility?
Yes, he is.
Thank you, I have no further questions.
Mr. Wright, you sit down. Have a seat, hold it, okay? Any other questions?
Your Honor.
Any for defense?
No, Your Honor.
Okay. Whenever you're ready, Mr. Wright.
This time, the people would move to find over on count 1, assault with a dangerous weapon, felonious assault. As we heard from the witness, he was a maintenance worker, supervisor for this series of apartments. While he was talking to one of the tenants of the apartment, another tenant we identified as the defendant came out of her apartment, approached him, started yelling at him. Eventually, she threw a brick at him. As he testified, as any reasonable person would be, he was afraid that he would get hurt by this brick. It was a portion of a brick, but as he described it, it was a 4x4, like 2 inches thick. It landed past him by about 2 feet, hitting his maintenance bag. At that point, he then rushed to go grab the brick so that it could not be thrown at him again. He immediately went to report it. People believe they had the burden of probable cause and would ask, move to find out this is.
And Your Honor, it's still a question of fact. There are other factual items that need to be resolved in further proceedings.
Okay, I heard testimony said from Mr. Wright, and I won't cite the facts again for everyone. I do believe the people have met the burden of proof, probable cause standard. I'm gonna read through the elements. First, that the defendant either attempted to commit a battery or did an act that would cause a reasonable person to fear or apprehend an immediate battery. I believe that's the case here with the throwing of a partial part of a brick. Second, that the defendant intended either to injure or make the complainant witness reasonably fear immediate battery. In this case, at least to make the complainant reasonably fear immediate battery with the throwing of the brick. Third, that at the time the defendant had the ability to commit the battery, appeared to have the ability, or thought she had the ability. I believe she appeared to have the ability and had the ability. And fourth, that the defendant committed assault with a dangerous weapon. A dangerous weapon is any object that is used in a way that is likely to cause serious physical injury or death. I believe brick in this case, although it was partial, a 4x4 with 2 inches in width, is significant enough to cause serious injury. So with that, I will have Ms. Anderson bound over for the arraignment on the information, date of March 9th at 9:00 a.m. at Frank Murphy Hall of Justice.
right, thank you very much, Your Honor. Always a pleasure.
Yes, it is.
This one is empty. Thanks. Just a sign. That's all good. That's all I want.
Okay, we are on the record that the people of the state of Michigan versus Carlos Bryant, 2258470. Mr. Bryant is charged with one count of police officer assaulting, resisting, and or obstructing. Today, they set for a preliminary examination appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Judge, you and your staff, Cody Bradford with NDS Detroit, P85944 on behalf of Mr. Bryant.
Okay, and my understanding that Mr. Bryant is not present.
That's correct, Judge. Neither of the officers are in this case.
Is that correct, Mr. President?
That's correct.
And Mr. Bryant is not present.
Not that I'm aware of, Judge. Judge, if I might briefly. The same situation we had last time, neither of the two officers in this case nor Mr. Bryant showed up. In addition to that, though, if you remember, Judge, I had filed this lengthy motion, which I know takes time for the court to review. You had instructed, it was not then APA Parrott who was here last time, it was Mr. Kirker. You had instructed this prosecution that they should respond in writing, you ordered them to respond in writing to my motion no later than February 14th. To this date, I still have not received that motion. I checked with your clerk this morning. I don't believe the court has received that motion. In addition to that, you instructed APA Parrott to be here today, and I do not believe she's here. So I understand Mr. Bryant isn't here. The things that you actually ordered the state to do have not been done.
So let's play your role. Mr. Kirker, anything?
Nothing from the people. This information was passed on. I did not have an update. I know APA Parish has been out for the last 2 weeks.
I don't think I've seen it since It's been a minute. I didn't know if she was transferred to the courtroom.
No, she's still in this courtroom. She
Okay.
is just now.
If Quiet was here, it'd be a lot easier to.
I understand.
uh, I guess what I'm willing to do is I won't issue cases because the complainant witnesses are present as well as the motion has been responded. So that would be a break for him and I'm also people to allow for them to respond. Of course, it messes up the timeliness of the docket, but that's not the biggest concern here. So as far as response to the motion, I have written on here, it says, written response, 14 days. It was very clear that I asked people to respond to, right? And that was to miscarriage. Mr. Parker, can you relay that message to Ms. Parrish that a written response is, we're waiting for that? And have you had any contact with your opponent?
Not since the PCC, Judge. I've tried several things. If the court is going to adjourn the motion hearing preliminary exam, I will contact the investigator at my office to see if we can find Mr. Bryant between now and the next court date.
Should we set this for a PCC with the motion? Or do you all want an exam date?
Whatever's easier for the court to. Okay, that's fine.
Okay. Let's see. March 7th, does that work?
Could we do the 8th? Judge, I think I'll be on trial still on the 7th.
I have 9 o'clock.
9 o'clock, okay.
And if the defendant's not present and plaintiff witnesses aren't present again, then we're gonna have a different outcome.
Okay.
Not sure what it's gonna be, but it will be different.
Okay, thank you.
You want anything else?
Nothing from the judge.
Okay.
Nobody checked in on red. 10:30.
Thank you, Judge. Great day to you and your staff.
Thank you. Still no 10 red, right?
Oh, man.
Okay. I'm ready to call that case. Oh, there's no defense charge. Okay, come up. All right.
This is fun. Oh, okay. This is good.
Everybody ready?
So we're gonna take it back there. I do have for the, on the attorney marathon, for the officer just got back to me that something can't make it.
That's fine. Roll on. Did they give another date? Any chance?
Sure, if it's extended a little bit down.
Okay, Mr. Parker, she called the court back after she had the 15th, the 16th, or the 20th, the 20th, and 22nd of March.
Any of those. dates,
Yeah, I'm sorry. I'm trying to recover from being Wednesday and Thursday. So, I'm sorry. So, 15. I want it to be done with not, maybe not what?
we're on the record. This is people of the state of Michigan versus J. Charles, case number 2355442. Mr. Charles is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic, 50 to 449 grams. Count 2 and 3, weapons, felony firearm. Count 4, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic, less than 50 grams. Count 5 and 6, weapons, felony firearm. Count 7, weapons, firearms, possession by a felon. Count 8 and 9, felony firearm. Count 10, weapons, firearms, possession by felon. Count 11 and count 12, weapons, felony firearm. This is a habitual offender report that is noticed and today's the date set for a preliminary examination appearances.
Good morning, Your Honor. Eric Decker, PA 59331 for the people.
And Robert, there's a one that I on behalf of Mr. Charles.
Mr. Charles, can you state your full name for the record, please?
Hold on, stand. That's not my real name, but it's J. Charles.
What's your real name?
Jamar with John Donaldson.
Say that one more time.
Jamar with John Donaldson.
Did you go by J. Charles? Okay. All right, you can speak. Thank you. And are both parties ready to proceed?
Yes, Your Honor.
Any preliminary matters?
Yes. We have a preliminary matter, we want to admit the preliminary drug analysis under 76611B1A and the certified register of actions under 76611B1B.
Council, see both of those.
I would object to both of them. No,
Council, can you step to the microphone so the court reporter can
let me
hear?
take a look at the.
There you go.
We're talking about the, try drugs in for But there's also, what about the
That's the certified copy of the for the felon possession charge.
No objection to either.
No objection either. Okay.
Okay, anything else?
The mutual sequestration of any and all witnesses with the exception of the officer in charge.
Okay. There is no one in the courtroom other than the attorney, staff, the defendant, and in fact, do you have, is the OIC here?
Actually, I don't want the exception of the officer in charge because I believe there's one person on the call. So,
Okay, all right,
so strike that, Your Honor. I apologize.
okay, anything else?
You have anything?
couple matters. One is that Mr. Charles is never Mirandized. So I would ask any statements that he alleged to have made happened on the
Statements he made to the police.
Yes, and also, while the reporting officer narrative indicates that he was read his constitutional rights, he was not, in fact, the same officer who supposedly read his rights, and interrogated him in prior interrogation, consisted of one question. Mr. Charles, have you drank any alcohol today? He said yes. and the officer were unable to update interrogation due to Mr. Charles having alcohol in his system. So that's interrogation that was made allegedly after any investigation was done. That was the whole.
That was one issue or all your?
I think that's two issues. The one issue is any statements you may have made prior to any alleged recommendation would be inadmissible. And the only statement he makes after he's supposedly Mirandized is that the officer can't do the investigation because the man's intoxicated.
Okay, Mr. Becker?
Your Honor, the interrogation, is not something that was going to be introduced today. However, any statement that is made by a defendant, during the raid, it seems to me like it's not necessary to have been, Mirandized at that particular point. Any utterance that he would have made against his own interest at that particular time would be admissible.
Okay, my question was going to be, are you even getting into the interrogation?
The interrogation that happened afterwards.
Okay. With that information, Counselor, I can rule, okay, no testimony based off of defense counsel's motion regarding interrogation.
Okay.
So with that, can you call your first witness?
Yes, Your Honor, the people called Kevin Briggs, Sergeant Kevin Briggs. Yes.
Speak up. Whenever you're ready.
All right. Good afternoon. So could you please restate your name for the record?
Kevin Briggs.
All right. Now, are you currently employed?
Yes, sir.
Where are you currently employed?
City of Detroit Police Department.
Okay. In what capacity?
Work for organized crime, major violators. Unit.
Okay. So what kind of work does that do you do for that?
Our unit focuses on narcotics activities across the city.
Okay. So how long have you been in that position?
I've been with narcotics since October of last year.
Okay, so then you would have, so were you working in that capacity on February 3rd of 2023 this year?
Yes, sir.
Okay. Did your duties as a police officer take you to 9437 Beaconsfield Street in the city of Detroit and County of Wayne?
Yes, sir.
Okay, does that address sound familiar to you?
Yes, sir.
Why did you go to that address?
Yes, sir.
Okay, why did you go to that address?
One of my members on my crew, Officer Nelson, had a warrant for that location. I'm the sergeant of the crew. On that day, we executed a narcotics search.
Okay, so what happened? When you arrived on the scene, what did you see?
When we arrived on the scene, we approached the location, announced our presence. We needed a response at the door. I ordered my crew to force entry to the location.
Okay, so after that happened, what happened?
I made entry into the location. There were a few individuals inside the location. They were detained. We continued to clear the location. And once the location was clear, I advised other units at the outside location.
Okay, let me step back for a second. When you say the individuals, do you recognize any, when you say the individuals, is there anybody in court today that might be one of those individuals that you spoke of?
Yes, sir.
Okay, could you maybe point them out and tell me something they're wearing?
One of the individuals inside that location is sitting at the fitness table wearing a green jumpsuit mask.
Okay, let the record reflect, Your Honor, that the sergeant has identified Mr. J. Charles. Okay, so, when you said you were clearing the area, could you describe what that is?
Clearing the location.
Clearing the location, sorry.
Yeah, we make entry to location. Our first objective is to get everybody that's inside the residence detained. So once that situation was taken care of, I deemed it safe for others to be outside.
Okay, so, so after you did that, what happened?
We did, after we did that, a few things occurred. I read Miranda rights to one of the individuals. Don't recall his name, I'll have to look at the report. And then I went outside and ascertained further information, making notifications to supervisor work.
Okay, so then after that, what happened?
At one point, I made entry to the location. I had an issue with Mr. Charles' name. The name that was originally given, I could not locate him in our systems. So I then personally went to him and began speaking to him, got the pat down of his clothing.
Okay, you say him, who did you mean?
Mr. Charles.
Okay, so then what happened?
During that pat down, I discovered he had in his possession, out of the person my report was pocket, he had some pills in one of his pockets. I then turned him over to another officer within the collective.
Okay, so then after that, what happened?
I finally was able to get his real name once I got the fingerprint scanner, or fingerprint scanner inside the house.
Okay, so then after that, what'd you do?
I found out he had some other issues, I believe a parole was down on warrant. Plus, pills came back to Schedule 1 drug, so he was arrested for that as well as parole.
When you say, what you say the pills came back, what do you mean?
Schedule, we had him, one of my guys, because again, I gave possession, I believe, to Officer Kelsey, but I'll have to purchase my report.
Okay.
And he came back to Schedule 1, I'm not, again, that's our purchase my report, I'm not sure exactly.
If we show you your report, would that refresh your recollection?
Yes, sir.
May I approach, Your Honor?
Yeah.
Okay. Got a touch screen and just scroll right here. Let me know when your recollection is refreshed.
I'm at the issue with enunciating the word, but I can spell it out.
Okay. So has your recollection been refreshed?
Yes, sir.
What is the what did you find?
Enunciate the word correct.
All right.
What did you say? I know you said you can't pronounce it.
Yeah, it's a problem name or a hard time enunciating.
Would be alprazolam.
That sounds correct.
Is there a more common name for that?
Yeah, I don't know.
Okay, fair enough. All right, so after the pills came back, then what did you do after that?
Again, he was still being issue with the name, so I went back to our name and got a fingerprint scan. Finally got his government name.
Okay.
And because of some besides the utterance that he stated when we first were inside the location, there were some items on the table. He claimed ownership of everything in the house. Besides the utterance as well, so he was arrested for what he had in possession and for his parole.
Okay. Nothing further. Thank you.
Awesome.
Dr. Briggs, what was, uh, how, how did the house on this particular house, how did it get to your attention?
I think it's our attention, we had, hit that location before. There's been numerous complaints about that location. It's a location that's occupied with several other neighbors around, so we have got another complaint about that. It's a location that's, in the neighborhood that has families, it's a fully occupied neighborhood.
And you said that you Mirandized. And so one of the, but there, who was, it? That wasn't Mr. Charles, was it?
I don't believe initially, no.
Jim, no way. Eventually happened with that individual.
That individual was eventually released.
Why did you detain that individual?
You said why?
Yes.
Because he was also inside the location of narcotic locations.
You recall the name of that individual?
We do have that name, but he's not in our initial report. We do have paperwork for everyone that was inside that location. At that time and date, it was only 3 individuals in that location.
So besides Mr. Charles and the man who was saying that was the third person?
Yes, sir. There was a total of 3 people inside the location.
Who was that third person?
Another individual inside, sir. He was also police counseling on our investigation.
No, Your Honor.
Now, the people call, sorry. The people call Lauren Kelsey. Thank you, Your Honor. Please restate your name for the record.
Officer Lamar Kelsey.
Okay, are you employed?
Yes,
Where are you currently employed?
Detroit Police Department.
In what capacity?
I work for the narcotics section.
Okay, so, how long have you been in the narcotics section?
A little over a year.
Okay, so that means that you were working in that capacity on, February 3rd of 2023 this year?
Correct.
Okay, and, did you work on that day?
Yes.
Okay, so in your capacity in the, with what you do, what are the kind of things that you do with your job?
For narcotics, we do surveillance details, we do search warrants, we do raids, the joint task force, operations.
Okay. Now, on the day that, that I asked about earlier, February 3rd, were you, did your duties as a police officer take you to 9437 Beaconsfield in the city of Detroit and County of Wayne?
Yes,
Okay, so does that address sound familiar for some reason?
yes,
Have you ever been to that address?
yes.
Okay, what happened, so when you arrived at that address, what did you do?
We executed a narcotic search warrant and I was part of the entry team.
Okay, so could you describe what happened?
We entered the location. Once I enter, I observed currency and assorted pills on the table, like in the living room.
Okay.
And I continued to go to the rear of the house. I observed the defendant in the northwest bedroom.
Okay. Let me step back just for a second. On that day, were you in uniform?
Yes.
Full or modified?
It's modified narcotics grade uniform.
Could you describe that for me?
Like a Molly vest with plate carrier with a helmet. You got the police on the right hand back.
Okay, so you said that you entered the location, and let's just let's go back to that. When you entered the location, what did you see?
It's a table in the living room. So if I will enter to the right of me, it's assorted pills, bottles, some outside the bottles, and currency on the table.
Okay, so then what else did you see?
Bunch of the dresser in the living room. Yeah, that's about it.
Okay, so based on those observations, what did you do?
We continue, so once we get inside of the location, we gotta clear the location for any animals or persons inside. There were no persons in the living room when we first entered that I seen, so we continue to push to the rear of the location.
Okay, so then after you pushed to the rear of the location, what did you see?
We cleared the room, I observed the defendant in the northwest bedroom, he was on the floor, it was an air mattress. It was him and some other person that was on the floor as well.
Okay, if you don't mind, I said take one more step back here. Now, you said that you saw, is there an individual in the courtroom today that you recognize from that?
Yes, Mr. Charles in a green jumpsuit with blue mask.
Okay. Let the record reflect that the officer has identified Mr. J. Charles, the defendant.
So reflect.
Okay, so then after you saw the individuals, then what did you do?
I actually detained Mr. Charles and we stood by, I believe they stayed inside the location. I took my vest off, went back to the van and I came back inside and started processing the evidence that was on the table.
Okay, when you say processing, what's that mean?
So since we were dealing with pills and the way our conversation goes, the pills have to be separated by name and we have to have a number by it. And some of the pills were stored as like a medicine container. So I transferred that to a plastic bag to make it easy to read.
Okay, you say like a medicine container, is that like, what does that look like?
Like a normal medicine container is like kind of 12 to 15 slots. You got a flap on it, you can lift up and got different pills inside.
Okay, is this like something I get from CVS?
Yeah, you can get pill identifier.
Okay, so then when you say you were processing, what pills were on the table?
It was a numerous amount. I would have to reflect my report to read all of it.
Okay, would you like if I showed you your report, would you be able to recall?
Yes.
Okay, Your Honor, may I approach? Thank you. There you go. Thank you. Not a touch screen, use the scroll.
Gotcha.
Let me know when your recollection has been refreshed.
I would have to read it verbatim. It's a lot of pills.
Is that, Your Honor, is that permissible?
They were all scheduled 2, 3, 4. It was over 10.
That would have to be a council.
Counsel, do you object to reading from the report?
No, you don't.
Thank you.
Just for the field identification.
Yes.
Which read words. Amphetamine and dextroamphetamine. 15
You can
milligrams.
spell it.
All right. AMP, HET, AMINE, and AND, DEX, TRO, AMP, HETAMINE. That was 15 milligrams of like a peach color oval. Has a stamp of E504 on it. And it was 68 of those. The next one will be ACETAMINOPHEN and oxycodone, OXYCODENE, comma, hydrochloric, HYDROCHLONDE. That was 325 milligrams / 7.5 milligrams. Stamped on there was 7.5 / 325 M522, the white oval pill, the quantity of 6 of those. Next one was AMP, HET, AMINE, and DXTROMPLETINIE, EXTENDED, RELEASE, ALTHET, salts, SALTS, in the orange capsule shape. It was 3 of those. The next one is ACETAMINOTHEN and OXYCODONE, hydrochloride, HYDROCHLORIDE. The quantity of 27 of those. Stamp was 325 milligrams / 10 milligrams. Stamp was C230, was yellow and round. The next ones will be OXYCODONE, HYDROCHLORIDE. Stamp was RP30, 30 milligrams. White round, it was 68 of those. The next one is OXYCODONE, HYDROCHLORIDE, 30 milligrams. Stamp was 30 M. It was blue and round, quantity of 42. Next one is OXYCODONE, HYDROCHLORIDE, 15 milligrams. It was stamped 15 M. Ring around, there's 20 quantity of those. Next one is ALPRAZOLAM, 2 milligrams, stamped B707, there's 31 of those. The blue rectangle. Next one is PAB, LORTAD, stamp was T325, which is 325 milligrams / 10 milligrams. The next one, it had a sample G037 on there, the white capsule with the quantity of 43.
You said 43.
Yes. And the next one were assorted Nike gym shoe pills, which were tested or for the processing unit that came back expensive on, and the quantity of 41 of those. Thank you. No problem.
Now, refresh my recollection, how long have you been working with the narcotics unit?
A little over a year.
So in your training experience, how are these substances identified?
Identified multiple ways. We call our prisoner, our poison, everybody option, poison control, or you can go to ID pill identifier, you can do it that way, or call poison control, which we did both, to identify the schedule and give them all that information and confirm that there's a schedule, what schedule it is, there's some narcotics.
So, so after you collected what was on the table, then what did you do?
I was collecting and I was standing there and I heard Mr. Charles state that everything in the house was his property.
Was, any statements been made by Mr. Charles?
I'm sorry, I can't,
Yeah.
speak in the mic.
Yeah,
For the
let me
court
just-
order as well.
Objection is based on the fact that Mr. Charles made any kind of statements made prior to being Miranda.
Was he in custody at this time?
No.
Mr. Decker, your response?
Your Honor, these statements were made to a police officer who was in full uniform and wearing a helmet conducting a raid. It seems as though any of those statements would be a statement by a party opponent, and it's in support of this statement.
We may have been handcuffed at the time. I'm not, I don't.
He was,
Was he handcuffed?
yes, he was handcuffed.
If he was handcuffed, then
I'm sorry.
if he was handcuffed, he'd be in custody and hadn't even right.
The statements that he made were in response to police questioning.
Was he detained or under?
At that point, he was just, everyone else in the house.
Okay, I'm gonna allow the chief to say, the council, I'll let you make argument. After that.
Okay, so then after you heard that, then what happened?
I observed Sergeant Briggs, beginning to check, Mr. Charles, and I observed him, pull out, this is my report, pills from his person, and, he transferred them over to me.
Okay, so then after that, what happened?
After that, I notated what the pills were, and I placed them in the individual sandwich bag. And at some point, I took to the room. I can't recall, but I tried to conduct the interrogation on Mr. Charles. And at that time, he said he had nothing to say, and due to his behavior, he was throwing up. So I believe he was under the influence of alcohol.
Okay, so did you make any more other recoveries?
No.
Okay, nothing further.
So pills that you read from your report, does that include what was allegedly found in Mr. Charles' person?
No. It's a back page to my report, which the pills are identified that I got off Mr. Charles' person.
No.
You said no more questions? Redirect?
No, Your Honor.
Provide me with the two items that were repeated.
Yes, sir.
Take on your laptop.
No, those are paper, old fashioned paper. One more witness, Your Honor.
No more witnesses?
No, one more.
One more.
There you are. Thank you. Your Honor, the people called Jalen Williams.
First, tell the truth, the whole truth, and nothing but the truth.
Yes.
Okay, have a seat and make sure you speak up. Whenever you're ready.
Okay, thank you. Please restate your name for the record.
Officer Jamie Williams.
Okay. So are you currently employed?
Yes,
Where are you currently employed?
Detroit Police Department Narcotics Section,
Okay, and in what capacity?
raid crew.
Okay. How long have you been working in that capacity?
2.5 years.
Okay. So that means that on the day of, so you're working that in on February 3rd of 2023 this year?
Yes.
Okay. So what kind of stuff, oh, I'm sorry, what kind of duties do you have as a police officer in that capacity?
Investigating narcotics, complaints or proactive, just investigations regarding narcotics.
Okay. And like what kind of duties does that, what does that entail?
Conducting a investigation, hope to lead into a execute search warrants for evidence recovery.
Okay. So you execute search warrants?
Yes.
Okay. Now, did your duties as a police officer take you to 9437 Beaconsfield Street in the city of Detroit and County of Wayne?
Yes.
Okay. What is the what does that address sound familiar to you?
Yes, it does.
Okay. So have you ever been to that address?
Yes.
Okay. Why did you go to that address?
I went to the address to execute a narcotics search warrant.
Okay. So when you arrived at that location, what was the first thing that you did?
My job for the search warrant was to breach the front door of the location.
Okay. So then after you did that, what happened?
I went inside the location and assisted with searching the locations of a person.
Okay. So then after that, what happened?
At that time, at this time, I observed the defendant in custody, placed in custody by group, not myself.
Okay. So then so now when you say the defendant, is there somebody in the courtroom today that looks familiar to you?
Yes.
Okay. Could you maybe point that person out and tell me something they're
Gentleman
wearing?
with the green jumpsuit, Mr. Char.
Okay. Let the record reflect, Your Honor, that the officer has identified the defendant, J. Charles. Okay. So after you saw the defendant, then what happened?
At that time, I stood by and I observed numerous narcotics on a table located inside the living room in plain view.
Okay. Why do you think what made you think they were narcotics?
Suspecting narcotics due to my past experience of recovering numerous narcotics that shapes and looks the same as I recovered before.
Okay. So then after that, what happened?
At that time, I observed Mr. Charles taken in custody and also observed narcotics being recovered off of him.
Okay. Did you do anything after that?
I did.
You didn't?
At that point, I took no further action.
Okay.
I'm sorry.
That's okay. Okay, nothing further. Sorry.
So you observed that my wife was placed in custody. And then what did you say happened after that?
I observed narcotics being recovered from this person.
No, was by the sergeant. That was by the sergeant.
I believe so. I can't recall. I want to say.
All right.
Officer Williams, would it help to look at your report to refresh your recollection about any other?
Yes.
Okay. Okay, Your Honor, may I approach? Okay. Go ahead. feel free to scroll right there and see if there's anything that you.
Yes, I do recall recovering 2 firearms from inside of the bathroom location. I forgot.
Okay, all right, so your recollection is reflect?
Yes, I'm sorry, yes.
Okay, so is there any other things that you recovered from the house?
I recovered 2 firearms and 1 loaded magazine that was recovered along with those 2 firearms.
Okay, so after you found those, what did you do?
I safely made them safe. I recovered those firearms with latex gloves and fingerprints, made it safe, and placed them on evidence at a later time.
Okay, so so then after you recovered the firearms, do you remember anything else?
I do recall the defendant stating that everything in this house was going to be.
Nothing further, Your Honor.
So you made them safe, what did you do to make them safe?
I'm sorry.
So you made them safe, what did you do to make them safe?
The firearms were loaded, so I wrapped a round out of the firearms to make it safe, so we didn't have any loaded ammunition inside of the chamber.
No, Your Honor.
Are you ready?
Your Honor, the people motion for bind over and reserve time for arguments.
This time we have no witnesses.
Right. Did you have argument? I forgot to ask you that.
What do you want to make, is that these statements that were made by alleged to have been made by John should be, and if he was not Mirandized at that time, the statements are very, statements. Might should have made a very, detrimental to last.
Yeah, Your Honor, the statements made by the defendant were a statement by a party opponent. They were made to a officer who was in full uniform during conducting a raid. It seems to me like a reasonable person would think that any statements made to a officer who was in full uniform is something that could be used against them. And the people motion for bind over the third circuit.
For her testimony from 3 officers, say Officer Sergeant Sabree. Officer Williams. What was the second officer's name?
Lamar, I'm sorry.
Lamar Kelsey. Okay,
Yes.
all right.
Sorry.
I couldn't find. Okay, Sergeant Kevin Briggs, Officer Lamar Kelsey, and Officer Jalen. Thank you. Okay. I'm not going to recite all the facts. The issue here, the defense counsel is whether or not the defendant's statement made to the police can be weighed, and whether or not the defendant is responsible for the possession or claim for. Basically, it's was in possession of the multiple different types of pills and the 2 firearms. Became a little bit confusing with the different drugs that were listed as far as the spelling and the amount that were found on the defendant's person versus on the table. I have a report, a laboratory report from Fred Police Department, preliminary analysis report that states that 104 grams of controlled substance, which came out to be 370 pills, were positive for controlled substance, and I have 13 grams came back positive for fentanyl. Mr. Deputy, correct me if I'm wrong.
Okay. That's fine.
Okay. So for count one, it says here, we intend to deliver 50 grams or more of oxycodone. Count four says 50 grams, less than 50 grams of fentanyl. For count four, I can see clearly 13.0 grams of fentanyl. For Mr. Decker, can you please look at this report? I'm having. So what I'm trying to understand here is for the first charge on 50 grams or more of oxycodone, on this report here, can you see where it shows the amount of oxycodone?
I believe it's right here, the 307 pills confirmed, drugs.com, the 104G.
And how do I know that that's?
I assume that because it says pills, that's, and considering that that was what was read into the testimony, that there were pills, that's the pills that were discussed in the lengthy list of pills that the officer read.
Okay, I have 41 fentanyl pills, 100 oxycodone hydrochloride pills, 71 amphetamine and dextroamphetamine pills, 76 acetaminophen plus oxycodone hydrochloride pills, and 40 alprazolam pills.
Yeah.
So all of these pills that are listed in the article submitted equal the 104, correct?
Correct. That's the way I read it.
Your Honor, I was on check based on the fact, well, drugs.com can identify what the pills look like. There's no testimony as to what these pills actually consist of. There's no lab report to analyze those pills.
Mr. Decker?
Those are, that's the lab report analysis
Okay.
from TrueNarc.
So for the preliminary examination, the preliminary analysis is allowed. So it's tested. You all get tested. So I'm still trying to figure out if it needs to be 50 grams based off of, because it has a number of pills here, but it doesn't show how much is attributed to the oxycodone. So 176 of the pills contain oxycodone. 40 pills contain alprazolam, which I don't know, I don't think has oxycodone, correct?
I'm not a chemist.
Me neither. Actually, I have a chemistry degree.
Oh, awesome.
It's not working.
Okay.
41 fentanyl pills, so. I understand what the issue is.
I do understand. I do understand.
I'm not trying to nitpick, but
I get it, I get it.
they bunched them all together in one box.
They did, and and what I would say is that for the purposes of preliminary exam, this is of course just a preliminary drug analysis. So I believe that a probable cause standard would be met by this preliminary drug analysis. If it's incomplete, then obviously the final drug analysis is the thing that would be presented to circuit.
So what I'll say is more than 50% of the pills here of the 104 grams are oxycodone. 171. Okay. All right, so that will take care of count one.
So, Your Honor, would you like this back?
No, yeah, actually, keep it. I'm gonna give it to you.
Okay.
So I believe the question of fact will be whether or not Mr. Charles was in custody or not when he made a statement. But based off of today's testimony, I do believe the people have met their burden of proof on all counts. And the controlled substances, now that I have a little more clarification, for counts 1 and 4, as well as the 2 firearms that were recovered in the house, and the felony firearm counts that are attached to it. So I'm going to have Mr. Charles bounce over on all counts with a ring on the information date of March 2nd at 9 o'clock. And I'm going to, well, actually, counsel, Mr. Jersey.
March 2nd, I have to be in the township that morning. For the personal exam.
It's an automatic date they give us. Is yours on a hold? You already answered that question, correct? He's on a hold on another case? Okay, so you're not in custody based off of this case, correct?
No, I got it.
Another case, another issue. Okay, I just wanted to make sure you weren't in custody based off of these charges. Okay. All right, so we're off the record on this case, Mr. Charles.
So you're saying my next court date is March?
1 week from today, March 2nd at 9 o'clock. Framework apologies.
What do you got going? I'm gonna find out.
Right. Oh. Yeah, one more.
Counsel?
attorney or the defendant. I'm just gonna call it. This isn't your case, so I'm just calling it up. Okay. Case number 2355341, people of the state of Michigan versus Jim Henry Red. Mr. Red is charged with count 1, weapons carrying concealed, count 2, weapons, firearms, possession by a felon, count 3, weapons, felony firearms, habitual offender, second offense notice. Today, the day set for preliminary examination appearances.
Alexander Kirker on behalf of the people, P862882.
And it's my understanding there's no defense counsel that's checked in on this case, correct?
Correct.
As well as the defendant?
Correct.
Okay, I am going to issue a capias. It will be $1,000 personal. Address that matter when the defendant is arraigned. We're off the record on that. We're on the record, this is people of the state of Michigan versus Alante Richardson. Case 22-60761. Mr. Richardson is charged with count 1, carjacking, count 2, weapons funding firearm, count 3, kidnapping, count 4, weapons funding firearm, count 5, motor vehicle unlawful driving away, count 6, weapons funding firearm, count 7, weapons carrying concealed, count 8, robbery armed, count 9, weapons funding firearm, count 10, weapons, firearms, possession by a felon, count 11, weapons funding firearms, count 12, weapons and munition possession by a felon, count 13, weapons, felony firearms. Count 14, police officer, assaulting, resisting, and or obstructing. Count 15, weapons, felony firearm. This is a habitual offender second offense noted. Also a commission with motor vehicle adult advisory for felony. Today is set for a preliminary examination. Appearances.
Good morning, Your Honor. Eric Decker, PA 5931 for the people.
And good morning, Your Honor. Good afternoon. I beg your pardon.
I'm sorry.
Attorney John McWilliams. My P number is 17565 on behalf of my client, Mr. Richardson, who's in the court. We're ready to, I'm sorry, we're ready.
Mr. Richardson, can you state your full name for the record, please? Are both parties ready to proceed?
Your Honor, the people are requesting an adjournment. We both, go ahead.
That's not exactly right.
Can you, I don't even know what he's going to ask. What he's saying.
The people are requesting an adjournment to March 9th. The officer in charge in this case is actually to my left right here. He has spoken to the complaining witness, and so have I spoken to the complaining witness. The only reason why she is not here today is because she says that she has concern for her safety. After the officer in charge and after I spoke with her today, she said that she does now want to participate. But because the reason why she's not here is because she feared for her safety. So I feel like that's good. So the people feel like that's a good cause in order for an adjournment. She will be participating. She is available on March 9th. She's a person who's a student, so we made sure that schedule is going to work for her. And if it works for the court, hopefully we would be able to adjourn until that day.
Your Honor, I'm going to object to that part of the issue at the present time. I have had the paper discovery this matter. However, when and if this officer takes the witness stand, I'm going to ask for an adjournment based upon the fact that they have not provided some very, very critical discovery in this material into this case, and that has to do with the body cameras. My client is going to insist before we go forward with the preliminary examination with this witness taking the witness stand, that they acknowledge that there are body cams, that they have not produced them in time for this preliminary examination, and I'm giving them a reasonable period of time to get them because my client says that those things are critical. Thank you.
I think your client wants to speak to you.
Oh, thanks. Your Honor, I'll amend my circumstances here.
Okay.
My client has been in the jail 4 months. Okay, this case allegedly took place on November the 18th of last year. He's been in custody all that period of time. And they should have been more prepared. And in that interim, if there was some type of affair, it should have been worked out. In the first place, my client has been in, he's in handcuffs. There should be no, there have been no other allegations other than the fearful face presentation made. It is represented to the court by me that the body cameras are extremely important. However, I'm insisting upon a dismissal at this particular time without going forward with any adjournments. Thank you.
Okay, so first, I have the register of actions here, it says that the incident happened, or he was charged, I should say, on November 18th of 2022.
That's my understanding.
Or November 20th, it's not clear, but November 18th or 20th. And that he was not arraigned until March 8th. I'm sorry, February 8th, this month. Does that sound correct, Ms. Richards?
They had me in there 72 hours, they didn't charge me again. They came to Wayne County, and months later, they kept telling me that it was going up on my arrest. I kept telling them.
Okay, I just want to know if that date sounds right. Okay, all right, so with that, Mr. Decker, do you have a response to Mr. McCool?
Your Honor, obviously, you know, the reason why he is in custody is because the charges are extremely serious. And it seems as though that it's for the interest of public safety and the interest that these cases be heard, especially considering that the complaining witness does want to participate after we discussed it with them. It seems like that's a good cause for adjournment.
My question is, and I'm not being insensitive at all to complaining witness, when did she disclose that she had fear for her safety, and what came?
She disclosed, well, I mean, the only times that I spoke with her only today, my supervisor spoke with her yesterday, and the officer in charge, when did you speak? And when did her mind change? She changed her mind today. I will say that she said that the notes in the file indicate to me that my supervisor said that she was going to participate today.
Okay, Your Honor, review my motion to dismiss.
So we have digital discovery issues, Mr. Decker, can you address that?
Your Honor, I can, this was handled by, the digital discovery as, I'm not aware of any outstanding digital discovery, but I will absolutely look at it today and I will get it to the defense counsel as soon as today, if not tomorrow.
Has anything happened, maybe the OIC needs to step in, has anything happened in between the date of the incident to now in which the complainant witness should report any threats or any complaints or anything different that's happened since the incident?
Well, like I said, Your Honor, at the time of when she showed the photo lineup, she showed a superior hand.
Okay, but no threats, no one called her house or saying you better not testify or anything of that nature? Okay, can you also put your name on the record?
Take it back to the
Thank you. Okay. And how long, Mr. Richardson, have you been in custody
Been in custody since November 18th.
on this case? I can't hear you.
Don't say that more than now.
So I'm concerned on both sides, actually, because this is, the nature of these charges are very serious. Also, Mr. Richardson has been in custody for a while, to even have a mandate. I will adjourn it, but I'm also going to entertain bond. Why?
I just took a plea agreement for 3 years already in prison.
So it wouldn't matter.
It's stopping me from going to prison right now. If you can.
You should probably stop. Talk to your attorney.
Yes, I'm just telling you, even if you was to give me a bond for a person, I can't leave it.
Okay.
Because I'm already just signed a plea agreement, I get sentenced next month.
The NGOC?
Yes, but this right here is stopping me. That's why if you can just dismiss it at the end of the day, you want to recharge me when I go to prison, they can breathe me back. As of right now, it's not going to go to prison.
You're getting time for credit serve,
Right, because this is a recharge.
but you're in custody.
Right, that don't matter. My lawyer, Christopher Sinclair, was supposed to take the case, but it's just all confusion. But as of right now, the 4 months that I've been here, they're supposed to be arraigned. My judge, Wanda Evans, told me that I was supposed to be arraigned on this in December. And then in January, never happened. I've been seeing the jail the whole December and January without no court. So adjourning it is just,
And Your Honor, just a point of order. I am assigned to this case. I was not into the case, although I'm somewhat familiar with what he's talking about. There's a lot of conversation. Put on the record.
Okay, Mr. Daniel, why the date of March 9th? I'm not, it's too far down the road.
That was actually the date that was suggested by defense counsel.
Oh, okay.
He suggested about March 9th, which is why I agreed to it, which is why that date came up. I wanted to go, we were first discussing doing it Monday, but then defense counsel said he was not available and he suggested March 9th.
Your Honor, would that be March the 1st, as your suggestion?
My suggestion would be tomorrow.
too serious. They should have been here today.
Still change your spot over for it. Plus, I'm telling you, for your best interest, you should probably, I know. I understand that, that's why I'm trying to get it tomorrow for you.
My complaining witness is I don't think she's gonna be available tomorrow, but I know that she said that she is available Monday.
She can be subpoenaed and to come tomorrow. Is she in town? Because we're all adjourning because of her.
I'm prepared to come tomorrow morning.
Please do. Yes.
Hey. Tomorrow morning, did you say?
Is she physically able to come tomorrow?
He's calling right now.
Okay, because I don't, in custody cases, I don't like adjourning, whether he has a hold or not.
What time, Your Honor, for tomorrow?
Did you say 9 o'clock?
11:30 would be okay for me, just as long as we don't get backed up.
Thank you.
Like saying yesterday.
You saying?
It's so serious. It's so serious. It's so serious. It's something so serious. They be saying something like this at 17, one of them, they will be there that day. She's still on just 2 days already back. I'm to Washington. My wife, same second year, she's supposed to be like 4 months. Ain't like this is just 2 weeks of this 4 months. I've been in jail waiting on this thing for it to get adjourned. Yes, sir.
If we're still on the record, Your Honor, my client is objecting.
Yeah, I'm very clear. I can hear his objection. Off record.
All right, I'll email you the.